Welcome everyone to VAWA Finally Passed, but what about immigration? A panel jointly sponsored by the American Bar Association, Commission on Domestic and Sexual Violence, Civil Rights and Social Justice Section, and the Commission on Immigration. Thank you for joining us today. We have two incredible expert speakers joining us, and they're going to be sharing some information with you. We will also be taking questions in the Q&A box. So please note them there and we will track them and set aside time for questions. But first, let me introduce our expert speakers. Grace Huang is the Director of Policy at the Asian Pacific Institute on Gender-Based Violence, a national resource center focused on technical assistance, training, policy, and resources to increase access to safety and justice for survivors of domestic and sexual violence from Asian, Asian American, Native Hawaiian, and Pacific Islander communities. Ms. Huang is responsible for coordinating the Institute's legislative, administrative, and court policy advocacy. Ms. Huang previously worked as an attorney, both in private practice and in civil legal services, representing clients in immigration, family law, government benefits, and housing cases, and currently serves as a commissioner on the U.S. President's Advisory Commission on Asian Americans, Native Hawaiians, and Pacific Islanders. Next, since May 2021, Archi Pyati has served as Chief Executive Officer of the Tahirih Justice Center, taking on the task of leading Tahirih in its service to more than 30,000 women, girls, and other immigrant survivors seeking safety from gender-based violence. She was the Chief of Policy and Communications at Tahirih before assuming the role of CEO. Before joining Tahirih, Archi served as Deputy Director of the Immigration Intervention Project at Sanctuary for Families in New York, where she ran a pro bono asylum program and worked with survivors to end female genital mutilation or cutting from occurring in the United States. Prior to joining Sanctuary for Families, Archi was a senior associate with the Human Rights Defenders Program of Human Rights First. My name is Vivian Huelgo, and I'm Chief Counsel of the Commission on Domestic and Sexual Violence, and I will now turn it over to Grace. And again, please note your questions in the Q&A box. Thank you.
Hello and welcome everyone. We're here today to talk with you all about the landscape of where immigration law is with respect to domestic and sexual violence survivors. And before I go into the presentation, I just wanted to flag for you all that Tahirih Justice Center and the Asian Pacific Institute on Gender-Based Violence, along with our colleagues at Assista Immigration Assistance and Esperanza United, we co-chair the Alliance for Immigrant Survivors. And we have formed a network of advocates and attorneys across the country who are interested in improving the policy landscape for immigrant survivors, and encourage you to take a look at our resources there. And the very last slide of this presentation will have a link, but I just wanted to flag that for you first before we get started. Today, we're going to talk about, as I said, the current immigration law landscape for survivors of gender-based violence, and then, hope that you'll all learn more about what's happening at the legislative level and as it relates to administrative policies and how they impact immigration protections for survivors. So before we get started, Allie, we just want to figure out who's in our audience today so that we can get a sense of how familiar folks are. If you don't mind just checking off the poll and letting us know if you've ever represented a domestic violence or sexual assault survivor in an immigration law matter, so that we can get a sense of the audience. So, I don't know how long it takes for that to come up. Okay. All right, so it looks about half of you haven't done immigration cases for survivors, and quite a few of you have done a lot. So All right, really helpful to know as we move forward. Okay, so I'm going to patch it off to Archie so that she can start with the landscape of where we're at.
Thanks so much, Grace. Hi, everybody. Thank you so much for joining us today, whether you're watching live or on a recording. And thank you so much to the ABA for hosting the Alliance for Immigrant Survivors, and Grace and I in particular today. I'll share with you just a little brief overview of the landscape. Right now, the legal landscape facing immigrant survivors of gender-based violence is complex and it's confusing. There have been so many different changes, first during the former administration, then again during this administration. It's a bit confusing especially to those who are not lawyers, but then also to those of us who are, what changes have happened that impact our practice, as well as what changes have happened that could impact our practice, but are actually being litigated or challenged. So many of the things that, we might read a newspaper article and say, wow, there's a big change afoot. Next thing you know, it didn't actually come to fruition. So there's been a lot of whipsawing and a lot of confusion. One thing I want to make clear, especially for those of you who don't maybe work a lot with immigrant survivors on a day-to-day basis, is that many immigrants, most immigrants, are actually still quite impacted by the pandemic. The change in the economy right when the pandemic hit meant a lot of unemployment among immigrants, and especially among immigrant survivors of violence. And it's important to remember that many don't qualify for numerous public benefits. They might qualify for some, but not others. And so safety net protections that are in place for other individuals, and in particular in place for survivors of violence who are citizens, are not in place for undocumented individuals or even individuals with pending applications. Survivors of violence who are immigrants, even with pending applications, often cannot obtain work permits. And that is happening because of delays that are ongoing. Also because sometimes they don't qualify for work permits yet. As a result, it's very difficult to find work that is above the table, work that offers you protections, work where you're able to assert your rights. And so folks are actually working, many individuals are not able to work or are working under the table, which causes the possibility of exploitation. Adjudications on cases are very slow right now and very delayed, and you'll hear more about that from Grace. Reunifications with family are very slow as well. People have not been able to come into the country for a couple of years. And so when individuals even when individuals have a successful immigration case and have the opportunity to reunite with family, those family members have not been able to make it into the country, and there are long waiting times and delays for them. That impacts immigrant survivors deeply. It's very difficult to move on from violence, to be able to deal with your trauma if the people you love and care about are not around you. Border policies right now, in the news all the time, whether it's Title 42 or migrant protection protocols, so-called, that really is also called Remain in Mexico. There's so much confusion. I know I look at the paper sometimes and I think I would have no idea what is going on if I didn't, talk about these things on a daily basis. Really, many thousands of survivors have been prevented from entering the United States and accessing their international and domestic legal right to claim asylum in the US, or to ask for other protection they might be legally entitled to. And so border policies, some of which were put into place expressly to deter immigrants, and others that were put into place under the guise of public health measures during the pandemic, but remain even while other public health measures have passed, are tending to keep individuals out of the country. That means often that they are not only are they not able to enter, but they're not able to access protection at all. And so they live in a sort of limbo state at the border. And there has been, a lot of reports of violence and harm, further traumatization at the border. And we'll talk a little bit more about what we can do about that as an advocacy community. Survivors also continue to fear detention and deportation. There have been really good strides in this administration toward prioritizing differently, making sure that individuals who are undocumented in this country and are survivors of violence are not first on the list for getting arrested, detained, and deported. And at the same time, there are many survivors who have been caught up in mass expulsions, including individuals who are Haitian, other nationalities that have been really subject to intensive internal enforcement operations to find them, arrest them, and deport them. And so survivors of violence are not free from being caught up in these mass nets and removed from the country before they've had an opportunity to assert their rights. Legislative wins have been pretty much non-existent the last few years. As you know, it's been very hard to move legislation. We'll talk a little bit about the Violence Against Women Act here in a minute. But other than that, there have been very few, if any, legislative wins that really center the needs of immigrant survivors of domestic and gender-based violence. That makes it all the more important that we are gaining on the administrative side. That means that we're able to approach the administration, have a two-way dialogue, and make real change. And that has been happening. The doors have opened. We've been having a lot of conversations. It's really good. At the same time, a lot of the wins we've made, and especially some of the bigger, broader wins, have been either have been litigated, and those lawsuits brought against the policies themselves have sometimes stayed those improvements, and therefore leave, again, confusion, but also leave immigrant survivors themselves out in the cold, unable to access the protections they are entitled to. Some of the priorities for the Alliance for Immigrant Survivors, including Grace and I, but also our peers and colleagues who focus on immigration law and also specialize in working with individuals who've experienced or fear violence because of their gender, are listed here. And we'll go into more detail about these as we go through the presentation. One of the things we're focusing on is improving the immigration provisions that you find in the Violence Against Women Act. On the next slide, I'm going to give you a little more detail on what those are. While VAWA passed already, but didn't include changes to immigration provisions, there are other legislative vehicles, and we'll give you some more information about that. Increasing access to benefits and supports, very important. As I mentioned, there are many immigrants in this country who are not able to get access, and they need it, in particular survivors of violence. So we'll talk a little bit more about that. Another priority for us is limiting further the detention and deportation of immigrant survivors. Trying to gain access to the legal system for survivors stuck at the border. We're trying to make it possible for them to get into the US, to get both access to counsel, as well as just to be able to talk to a judge or an asylum officer at all. And finally, the asylum law itself, as it is written, makes it inaccessible for many immigrant survivors of violence in particular to get asylum. Many don't know that they even qualify because it never specifies that they do in the law. And also, many immigrant survivors of violence are turned away at the border and told that they don't qualify, which is false, by border officials who don't themselves necessarily understand. But through litigation, the law has been expanded and one might qualify, but it's not written anywhere. It's not clear at all. And so we are trying very hard to make those provisions more fair and more accessible. Having explained those priorities, I'll take just a moment. This slide is pretty, what's the right word? Complicated. It's a nice visual representation, but there's a lot of information here. I know a question, if it hasn't already come in the chat, will the slides be available? And they will be. And so you'll be able to study this beautiful graphic a little bit more carefully. For now, I just want to make clear what this is that you're looking at. You're looking essentially at a visual depiction of some of, and there are others, but some of the ways that a survivor of violence who is undocumented might access immigration status. Why is that important? By being able to make an application for immigration status, an individual who is afraid of being re-victimized or who has been victimized and needs to get away from that exploitative or violent situation may not be able to qualify for things like extended subsidized housing or food stamps or WIC, things that she and her children might depend on, or healthcare for the individual, regardless of gender or gender expression. These individuals need immigration protection as one piece of the puzzle for them in order to be able to access safety. So these are some: the T visa, Violence Against Women Act, self-petition, the U visa, continued presence applications, SIJ, which is special immigrant juvenile status, and asylum are some of the ways individuals might get status. You could do it, they could get it other ways, through work, through family members, petitioning, through other things. But this is sort of the range of humanitarian bases on which they can get protection. In other words, they may not need anybody to sponsor them, but the government makes an effort to give them an opportunity to obtain protection here in the US. Again, lots to say on these pieces, but I'm going to go from here into the next slide and welcome, oh no, this is me still, sorry. We're going to talk for a minute about the Violence Against Women Act more specifically. Now, in the Violence Against Women Act, some of those pieces show up, right? The being able to petition for yourself, saying that you've been, in 94, when Congress passed the Violence Against Women Act, it recognized that there are a number of women who might be married to abusers and at the same time be unable to access status on their own through their abuser. So they have to be able to access status on their own in order to get to safety. So there were immigration provisions put into the Violence Against Women Act. Additional provisions were added over time, and every 5 years it's supposed to be reauthorized. So just this year, finally in March, after many years of trying, and those of us who organized this call from the ABA, as well as Grace and I, and many of you who have joined, probably played a role in trying to get the Violence Against Women Act reauthorized. So congratulations to all of us for that. There are some really important changes that are worth celebrating, and there were too many to list here. So if you're not familiar with those changes, we can give you more information later, but a few things to note. The Violence Against Women Act defines 4 types of violence. What it doesn't define is forced marriage, and we experienced in the past as an agency, and many agencies did, certain kinds of violence that our clients might go through, and yet when we referred them to VAWA sponsored or VAWA funded agencies, we sometimes would get a reaction, well, we don't know if we can actually serve your client because your client is not a survivor of stalking or dating violence, domestic violence, or sexual assault. Your client fears forced marriage or has experienced a forced marriage. So now we have a definition of forced marriage under VAWA, which is a big improvement. Access to emergency and short-term housing, restored tribal jurisdiction, increased resources for culturally specific communities, so many other resources, economic justice provisions, and other things that are really, really important. We'd love to talk more about that if you are interested, either later in this presentation or at another time, or again, at our websites, we have in extensive descriptions of the VAWA provisions that have been really positive and that we worked hard for. At the same time, there were significant needs that immigrants in the community had for changes to the Violence Against Women Act in order to make it possible for them to actually realize the rights that Congress intended back in '94 and along the way. And at this point, none of those provisions were actually passed through Congress or signed into law. And so we have a lot that we still need to achieve. And I'll turn it to you, Grace, to talk a little bit about what some of those things are that we are looking to achieve.
Sure, thank you. I was just trying to respond to a question, but I'll finish that in a minute. Anyway, so, some of the things that we tried to get included in VAWA relate to long-standing challenges that we've had in implementation of existing immigration protections, and those include numerous challenges relating to how long people have to wait to get their cases adjudicated, the Violence Against Women Act of 2000. It created the U visa program, for example, which limited the program to 10,000 visas a year. The VAWA provisions, have only apply to spouses and children and parents of U.S. citizens or spouses and children of permanent residents who've been abused by their spouse or parent. Those have long wait times. Part of the issue is, the pandemic really took a toll on the number of adjudicators available, as well as closures of offices, all sorts of things. And so, this slide just shows how long, if somebody was applying for one of these statuses right now, how long it would take for their application to be reviewed initially. And so if you were helping somebody, apply for a self-petition under VAWA, it's taking over 2 years for that application to get processed. And for those, who are applying for U visas now, right now they're processing cases from 2017. And so next slide, Archie. This gives you just a sense of how, what the backlogs look like for U visas. And so, right now, what we are seeing as of just the end of last year is that there are over 173,000 initial, primary applicants. And then, if you include their children or their derivatives, there are over 286,000 people in that U visa backlog. And given that VAWA right now only, allows for 10,000 visas a year, somebody who's applying right now will be waiting for probably over a decade and a half to get their U visa on there. And so, we had been hoping in VAWA to be able to raise the U visa cap, to lift it or to eliminate it altogether. And so that, is something that was left out. We had also, hoped to get other provisions like, more timely access to employment authorization, to fix a whole bunch of different barriers in the law as VAWA exists. I want to make clear to everybody that just because they didn't make improvements or changes to the immigration provisions in VAWA that was just passed, in March, that the existing statutory provisions are still in law. And so it's not like the relief is no longer available. It just means that, some of the longstanding administrative issues that relate to processing these cases didn't get resolved. And ultimately it means that, like I was explaining, that people won't have access to status as quickly as would be ideal, especially for survivor who's trying to escape an abusive situation, who needs to get access to work authorization, who needs to be able to, access the resources they need in order to get help. And so, since it didn't get passed in this last Violence Against Women Act, we, will be looking for other vehicles to be able to improve the legislation. And ultimately, some of the, longstanding challenges of the program have to be fixed legislatively. They can't be fixed administratively. But though we know that this administration is working really hard, and we have some allies inside the administration working really hard to try to improve the protections for survivors as much as possible. If you want to go on, Archie. And so, we do know that when this administration began, next slide, that they, tried to undo some of the worst provisions or the harshest provisions that limited access to a whole range of programs in the immigration law. And so we know that President Biden, his first day of office, he rescinded, some of the initial executive orders that the last administration had put in place. And an important one included rescinding policy guidance that allowed, USCIS, the service agency, to, refer cases directly for deportation in the notice to appear memo. So that's an example of one thing they got rid of the very first day. They also undid the travel ban that had limited the ability for folks primarily from Muslim majority countries, but other countries as well. And asylum applicants, they undid an executive order that really limited immigration in that context. And then President Biden issued an executive order to review the entire legal immigration process. And so, some of the things that they did included undoing a bunch of policies that were put in place. For example, I don't know if any of you read about this in the news, but the last administration, for example, had a policy in place where somebody submitted an application and didn't fill in every single line on the application, what they called their blank space policy, they would reject the application. And what we were seeing were applications where people, like if they didn't have an apartment number filled in because they lived in a house and didn't have an apartment, they didn't fill in the apartment number line. And, if they didn't put N, not applicable in each of those blanks on the entire application, like in the spaces where there might be for names of children and you have no children, those applications got rejected. So, that policy was revoked. Some of the extra review of already adjudicated cases, what we call the extreme vetting policy. We were hearing about cases where, the agency was going way back and reviewing old applications that had been approved and opening them back up. There was all sorts of litigation that had been filed challenging some of those policy. There was the new administration settled some of that litigation, including, for those of you familiar with the public charge regulation, which public charge is a ground that makes it so somebody who's likely to become primarily dependent on US government benefits can be denied status. The last administration greatly expanded, the scope of that regulation, and it was challenged in litigation. And right now, the status of it is that the agency had settled that litigation and went back to prior 1999 guidance. And so the new administration's, put together a new rule about that, and it's, a notice for comment, and, is likely to issue a new regulation about that in the next couple months. There was all sorts of things that this administration has done to try to undo some of the harm that happened before, and is, going through the process of trying to reinstate or create better processes in many arenas. The next slide, please. One very specific example was this in the context of U visa application. For example, so the U visa application, it involves, you have to get a certification from law enforcement that certifies that you've been helpful in the investigation or prosecution of certain criminal activity. And then, the applicant has to show that they've suffered hardship as well, or harm. And then the application goes into the service. And what we, like I said earlier on the earlier slide, I showed you that they're processing cases from 2017, they were, looking at issuing work authorization in those applications, from that date. And so we're talking about 5.5 years before somebody has any indicia that they might be here lawfully. And so what this agency, the administration chose to do was create what they're calling the bona fide determination process in the U visa, because there are only 10,000 visas a year. And we know that all of those people that are in the pipeline, have to be able to work to overcome the abuse, to contribute to our communities, to escape and recover. And the administration chose, instead of making them wait that entire time till their application was processed, they created what's called the BFD, or the bona fide determination process, where they are going to be, doing a cursory review, initial review of the application to see if it appears to be a bona fide application, and if so, issuing what's called deferred action and issuing a work authorization for those folks while they're waiting for their visa to become available, probably in 10 to 15 years, for example. And so, there's a link in the materials to the guidance and the policy about it. And the idea is that, folks, once they get their backlogs reduced, I mean, unfortunately, fortunately or unfortunately, they are looking at cases first in, first out. And so right now they're looking at those cases from spring of 2017. And hopefully with it, more resources going to the agency to be able to work on their backlogs, that backlog will, be significantly reduced. And hopefully soon people will be able to apply and hopefully be able to get work authorization rather quickly while they're waiting for that visa to become available. Next slide. Oh, yeah, next slide's for a graphic of the process, and you'll get this when you get the slideshow. But really, this is intended to be just a physical manifestation of the flow chart of how that process works. There will be some people that aren't eligible for the bona fide determination process, and usually those are people that might have prior deportation orders in their history, or people that might have certain criminal convictions. And so in that instance, they won't go through the bona fide determination process. They may be put on a separate wait list to be, for the review of the case. And for that wait list, it again is a very similar timeline, but it just won't happen as quickly as most likely the BFD cases. And so next slide, please. Another thing that the administration did do is they have what they're calling the ICE victim-centered approach, which is for immigration and customs enforcement. The idea being that there is direction from headquarters that ICE officers, immigration customs enforcement officers, really need to be looking at the purpose of the protections that exist for victims, and make sure that they're not a high enforcement priority. And so as a general rule, the guidance instructs ICE officers to refrain from engaging in or taking civil enforcement action against, applicants, beneficiaries of a victim-based immigration program, or those who are known to have such a case pending. And so in some cases, like for example, if somebody's already in removal proceedings, they may work, with the services part of the agency to expedite, review of the victim-based application. And then in cases where it seems like somebody might be eligible but hasn't actually applied yet or doesn't even know about it, they're also supposed to look at the fact scenario and figure out whether that person merits, positive exercise of discretion. And so the guidance link is in the materials. You'll have access to that. But that's a positive step in comparison to the last administration, where there just really wasn't any uniform guidance, and really everybody was a priority for enforcement. Anybody who had been undocumented or had entered the country without inspection. So next slide, please. Another important guidance that was issued for those of you who do work at the courthouse or regularly, there's a new guidance around called protected areas, and generally these areas are protected from or generally ICE is not supposed to be engaged in enforcement activity at this certain list of locations. And I forgot, and I'll have to get that to Vivian later, but there's also another guidance specifically about courthouses. But as a general rule, places where victims go, places where kids congregate, religious institutions, hospitals, etc., places where people, it's generally in the public interest for people to not be afraid to go. That the guidance instructs folks to refrain from engagement, immigration enforcement generally. And so hopefully, we're looking for, if violations of the policy or examples where, the guidances are not being followed, so that we can make sure that, we're coordinating with headquarters to make sure that folks are accountable to headquarters guidance. And then finally, another victim-specific administrative policy improvement was, I guess, the increased focus on victim assistance and support. In the prior administration, there was what was called the victim, I can't remember anyways, there was a prior
It was
hotline.
Victims of Immigrant Crime.
Yeah. And hotline, and essentially was a place for people to call if they felt that they'd been victimized by an immigrant. And this administration shifted the focus of its hotline to be one more of support for for victims generally, not specific only to immigrant victims, but also to immigrant victims, and just really it's a place to get information and support for victims to understand more about the immigration system, and also for law enforcement, for example, who have questions as they're providing certifications for U visas or trafficking visas, et cetera. And so these new resources are there available for the public and for advocates and victims themselves to be able to get more information about the system. And I'm going to pass it back to Archie to talk about border policies, changes, et cetera.
Absolutely. Thank you, Grace. So Grace has been talking about, what changes have happened that are helpful to individuals who are already in the United States, right? People who are immigrants, who are in the US, who are trying to, who've been victimized here and are looking for safety. That said, there are a number of people who are at the border trying to get in still. And so I'll talk for a brief moment about those individuals and what they're facing right now. A couple of things that we are really concerned about as advocates who assist survivors of violence are things that are keeping folks out. One of them is migrant protection protocols, which is a false name. There's nothing about these protocols that actually protect migrants. In fact, as I said earlier, it's really, we call it Remain in Mexico. It's really a policy that closed off the border and said, if you want to seek asylum, you have to do it from the Mexican side of the border instead of coming into the US in order to file your claim. Well, that's really difficult to do when all the lawyers who are experts in US law and are barred to practice US law are located inside the US, where and advocates and social workers and other people you might need. It's also really difficult when the judges, the courts, the asylum officers, everybody who's a part of the process to get asylum, to get protection, are also on this side of the border. And so as a result, thousands of people over the last handful of years have been stranded in Mexico. They have not had access to the system. Our asylum law essentially comes from international law. After the Holocaust, many decades ago now, and actually yesterday was International Refugee Day, where we celebrate the Refugee Convention, a treaty that established who is a refugee, who gets to be called a refugee, and how are we supposed to treat them. That treaty is something that, and the protocol, meaning another document that's attached to it, was signed by more than 180 countries, including the United States, which ratified the protocol and thereby the treaty, saying that we would abide by it and make sure that individuals who didn't feel they could be protected by their own governments, so they're living in their country and they feel they're being persecuted in their own country because of something they cannot or shouldn't be asked to control, their race, religion, political opinion, membership in a social group, or national origin. They're being persecuted because of one of these things and they need to get out and they need to get to safety. We are obligated to give them a chance to ask for that protection here in the US. The way the US government operationalizes that is by taking the definition of a refugee from that international treaty and making it a part of our US immigration law. If somebody is in their home country and is en route out of their home country, I should say, and finds themselves in another country trying to flee persecution, the US might adjudicate that individual, decide that individual is a refugee, and bring them into the United States as a refugee. If the person crosses into the United States and decides to ask for that protection once they're here, they are seeking asylum. But ultimately, the definition of the two people being a refugee, one outside the US and one inside the US, is the same. What's happened, however, is that people who are trying to get into the United States to make that request, as they have a right to do under the law, are unable to do that because of the Migrant Protection Protocol. So if you see some of us in the movement, Tahirih Justice Center where I work, or other organizations filing lawsuits, speaking vocally, saying MPP or Remain in Mexico needs to go, what we're talking about is opening the border to individuals so they can get into the United States, use the law that's put there specifically to give them a channel to ask legally for protection and to file those claims. They're not being given the opportunity to do that. For survivors of violence, as I said earlier, the definition itself, if you heard what I said before, I listed 5 reasons you might want to apply for asylum or might qualify for asylum. Nowhere did I say the word gender. So for individuals who are fleeing domestic violence, sexual assault, rape, in the context of anything, of gang violence, in the context of conflict, in the context of just being in a home where they are unable to get away from it, they can't get into the United States to ask for protection. And on their way, when they're at the border officials themselves are saying you're not able to come inside the country and ask for the protection for which you qualify. As a result, individuals, including women, including children, including transgender individuals, including gender nonconforming individuals who've been persecuted, are sitting in Mexico waiting to get in and cannot get in. So we're trying to repeal MPP. We're filing lawsuits. We're working with our colleagues. That has been going on for years now, and it still has not been repealed. Also, Title 42, another significant issue that we're working on at Tahirih and other organizations are working on as well. We want Title 42 to end. Title 42 was put in place by the Trump administration at the start of the pandemic, saying it justified expelling, not just keeping out, but also expelling immigrants already here for public health reasons, okay? It was advancing a narrative that goes back centuries of immigrants who come to this country bringing disease or bringing health problems. It's very, very common. It's older than dust, this idea that immigrants are somehow unsafe for us in America. And it continued to be the narrative in this policy. But over time, what we saw was as mask mandates were dropped, as flights no longer needed masks, you name it, it's gone to the wayside. And yet Title 42 continues to stand in place. We are seeking that it be repealed from this administration. And we're filing lawsuits also at the Tahirih Justice Center, but others are involved. We want to see that, we want to see these policies repealed. Until they're repealed, honestly, we can't do our job. We are here to assist, to provide legal representation and social services support to immigrants who are seeking protection in the US. We can't do that if they can't even get in here. And so our work is to open the border so they can get in, so they can ask for, they can seek asylum, and we can represent them in court. That's what we're trying to do. I'm in charge of the slides here, as you can tell, so it takes me a second. Okay, asylum policies. I just explained what asylum is and how it works in the US. That was like the crash 1-minute, 2-minute course. But if you understand even that much about how asylum works, if you haven't represented somebody in an asylum case before, then you know that much of what goes into asylum law is not in the statutes. The statutes are actually pretty silent on asylum law. Where asylum law is really explained is in regulations, in rules. It takes place a lot in like training manuals. A lot of how the asylum law is actually adjudicated, how an asylum officer says, okay, the statute is like one paragraph, but I have 100 different people this month I'm supposed to talk to and figure out who gets asylum. How am I supposed to do that? Well, what you do is you read the training manuals, go through the trainings, and you also you read the cases that came before you. So precedential and even in many cases, non-precedential cases that these asylum officers and immigration judges are reviewing. These things the administration has jurisdiction over. So this administration can make changes to lots of different aspects of immigration law, in particular as it relates to asylum, simply by tweaking things, by issuing regulations, but also by tweaking things like policies and manuals that are issued on a regular basis. There are so many improvements that need to be made. We don't even have time for that here today. But there's one example, a very simple one, called LIFO, as we say, or last in, first out, which has created so many problems and nightmares for our clients. Essentially, if you apply today, you'll be the first one to be adjudicated. But if you've been sitting here waiting for 7 years already, you're just going to be waiting longer until they get through and go in reverse. But the policy came and the policy went and the policy came. And so there's so many people who just got stuck without an opportunity to be seen. During that whole time, they're afraid of being evicted. They don't qualify for most benefits. And if they have a work permit, which they should, they have to continually get that reinstated. They have to do many applications to have it reauthorized, and that takes time. It takes money. It takes a lot of effort and money, in particular, if you have an attorney that's charging you to file those. And so one after the other, policies like this that don't make sense and that are causing delays and problems for our clients continue to stand, and we want to get those repealed, and we want a more common sense process for helping those individuals who qualify for asylum to be granted and those who don't to have an answer so they can get on with their lives. Work permits as well. There have been some really great changes issued by this administration, lengthening the time that renewal periods are good for. In other words, I have a client whose work permit is going to expire. I can file for a renewal, but the sort of grace period goes on much longer and the renewal window is much longer. That's wonderful, but still the delays are so horrible that really what we want is for the adjudications to happen in a timely way. It's great to keep giving more extensions, but actually just adjudicate the applications. Let's talk about some legislative priorities and some of the answers to the problems we've been outlining. Some of it can be done by the administration, but a lot of it has to be done through new legislation. We talked about what VAWA did accomplish, but we also shared some things it didn't. And so Grace is going to walk you through a number of other legislative vehicles that might help us get to where we want to be.
Okay, so as Archie had mentioned, we have identified, and some of these are longstanding priorities that we've had, some of them going back from before the last VAWA reauthorization, which was in 2013. But as we have been working in collaboration with our partners as well as with Congress, in putting together, drafts of legislation. And so these are some of the pieces that we have been working with members of Congress on. The top one, or one of the very top ones, is lifting the cap on the number of U visas that can be issued a year. Right now, it's only 10,000 visas, and we've got 170 some thousand people in that backlog. Plus their family members. And so some of the things we've talked to Congress about include, just getting rid of the cap altogether, like whether it's, just having no cap so that they're unlimited, or other options. And the administration has, in the past identified maybe about 30,000 visas a year, because that's about how many applications they've been getting every year. Another thing we've talked to Congress about has been recapturing unused U visas from early days in the program. As I had mentioned earlier, the U visa was first created in 2000, and there were no regulations that were written or implementing that program promulgated until 2007. And so what we know is from fiscal year 2001 to about fiscal year 2009, because there had been no implementing regulations, there were about 10,000 visas each of those years that never got issued to anybody. And so one of the things we've told them, if you're not willing to eliminate the U visa cap or lift the number, at least let's, try to get at least half of this backlog cut down, and, issue the 85 to 90,000 visas that are sitting out there that were never used. And so that's one set of priorities. We've talked about, not detaining or removing survivors that might be eligible for relief, statutory, putting a statutory timeline on how fast people should be able to get work authorization. This one was a newly identified one from the last administration, because the last administration created a process that allowed the benefits issuing agency USCIS to refer people over for deportation if their cases were denied for whatever reason. And so one of the things that we have identified as priority is limiting the ability of USCIS to share information about that they gather from survivors as they process these applications to other agencies like ICE. Other, priorities include increasing access to public benefits, housing, health supports, allowing for alternatives in the U visa certification process, such that people who live in jurisdictions where law enforcement refuses to issue, do a U visa certification, perhaps allowing some other method for people to be able to obtain proof or show that they did cooperate with law enforcement, for example. And then, as Archi had mentioned, recognition of gender as a basis for protection in asylum law. And so I'm just going to talk about some of the existing bills that live out there, or processes that are happening. So next slide, Archie.
Grace, before you keep going,
Oh,
someone asked a question. What is an unused U visa? I thought others might be curious about that.
Oh, good question. So, when somebody actually is approved for a U visa, they issue a U visa, which is allows the person to live in the United States, and puts them on a path for the ability to apply for permanent residence after 3 years, having that U visa for 3 years. And so it's a marker of lawful non-immigrant status. And so there's, like I said, 10,000 available each year, and then children don't count against, or derivatives don't count against that cap. And so since there have been about 30,000 people applying every single year since 2010 or so, average 20 to 35,000, like depending on the year, and it went down significantly during the last administration. But so there's a buildup of about 20 some thousand people every single year that the program exists, meaning there's a whole bunch of people that won't be able to get a U visa until if you were to apply right now, and if you kept the same numbers and the same processing time, it'll be 17 years before, if somebody were to apply at this moment, before they'll have access to that, protection against deportation, essentially. And so, we have been pushing for years to try to lift that cap, or try to recapture, because there was, I don't know how else to say it other than there are, some in Congress that do not want to increase legal immigration. They don't want more legal immigrants. And so, one way that we've tried to provide an alternative or compromise is to say, well, there were all of these U visas that were never used in the early years of the program, so use them. So, but that hasn't. We're still working on that. Okay, so next slide. So some of the things that are coming up, have been bills introduced, but one of the things that I guess these are some of the vehicles that have some of the protections we're asking for, or some of the legislative provisions that we're asking for. But and I'll go over them in a minute. But the biggest one being right now, appropriations that's happening at this very moment for the next fiscal year. And so next slide, please, I think. The process is going on right now as we speak. And so they're going to be, working on the bills that fund the government starting in October of this year for fiscal year 23. And so in the appropriations process, this is how VAWA passed actually this last, during the last omnibus appropriations bill that got passed, I think in February or March. VAWA got attached to it as an amendment. And so one of the ways that we can think of, we've been hoping, and since appropriations is a must pass piece of legislation, and getting appropriations passed is like the epitome of what you all hear about when we talk about legislative process being sausage making. I mean, there's just like the appropriations process has, the lots of things attached to it. Let's just put it that way. And so some of the things we've been asking for, we have members of Congress that are looking to put our, provisions such as recapturing unused U visas, or putting restrictions on ICE from being able to, take adverse action against survivors, like provisions like that, that various members are trying to attach to the appropriations process. And we have, a full appropriations committee hearing markup of the DHS appropriations bill that's coming up this week. And so, we know most likely overall the entire, as the process goes on, it probably won't be till fall that a final appropriations bill for next year will be passed, but they're working on negotiating all the provisions right now. And the elections will have a big impact on what gets included or not included. And so we are working with members to try to attach positive protections, and I know there will be others working to attach negative provisions. So there's appropriations. Next slide. We are in terms of all of our most of our priorities related to VAWA and U visas. We've been working closely with Representative Pramila Jayapal, who is going to be introducing in the next few month or so. We're still working through the details of some of the last provisions. She'll be introducing the Working for Immigrant Safety and Empowerment Bill, or otherwise the acronym will be called WISE. And that bill will include language that, for example, lifts that U visa SIJ cap, has provisions putting a time frame on when work authorization needs to be issued, limits detention and removal of survivors, opens up access to public benefits, housing and health benefits for lawfully present survivors, and creates protections for like abused spouses, self-petition type protections for abused spouses of those here on non-immigrant visas. For example, like if you have a primary visa holder who's here on, I don't know, a diplomatic visa or a employment-based visa, non-immigrant visa, and their spouse is here as a derivative on that application. What the bill does is create a process so that they don't have to stay with that abuser to be here lawfully and be able to work. And then there are other provisions that have been longstanding, gaps in our existing provisions, such as, for example, if you entered the country on a fiance visa and you don't end up marrying the person that sponsored you, you're not eligible for VAWA self-petitioning or other immigrant survivor-related protections, to be able to get your green card in the U.S. And so it fixes a bunch of gaps like that in the law. And we'll be hopefully introducing that bill soon. And we're, in the process of talking with senators about sponsoring a Senate version as well. Next slide. For those of you who weren't aware, some of these provisions, this is a bill that includes, the same provisions that were in the WISE bill, but were the most, urgent during the last administration. Representative Jimmy Panetta from California had introduced a bill that lifted the U visa and special immigrant juvenile visa cap, had the 180-day, time frame for work authorization, limiting confidentiality and information prohibitions, or there were information sharing prohibitions with ICE, and then strengthening confidentiality protections, and then limits on the detention and removal of survivors. So very similar to some of the provisions in the WISE bill. And so that bill has already been introduced. And right now, I think only has one co-sponsor because we've really focused our energy on trying to get a more comprehensive bill introduced. But it's a great bill if we can get that attached to something too. Next bill, or next slide. This bill, I think the Lift the Bar bill, what this bill does is really revamp the public benefits system as it relates, or the immigration restrictions on public benefits. And so what it does is deem that everybody who is lawfully present in the United States is considered qualified for certain federal public benefits. So would open up the food stamp program and or the Medicaid program and or TANF and SSI to those who are lawfully present. And, we like U visa applicants, for example, are explicitly named in these bills because, when those initial immigration rules related to public benefits were written back in '96, U visas didn't exist yet. And so one of the specific things we wanted to make sure has been in the law is that U visa applicants are qualified for federal public benefits, which currently they're generally not. And so for those of you who are more interested in this bill, it's been introduced. I think it's got about 100 some sponsors on the House side, and then Senator Hirono has just introduced it on the Senate side and is looking for co-sponsors right now on the Senate side. And so for those of you interested, the Protecting Immigrant Families campaign is taking the lead on that. And there's a fact sheet specifically on how it impacts survivors on this slide. And then let's see here, a few more. The next one, this bill that Senator Klobuchar has introduced, S-260, speaks to, the self-petition protections for non-immigrants. And so it's a sliver like that we included in the WISE bill that allows for self-petitioning for abused non-immigrants. And then I'm going to pass it back to Archi to talk about some of the asylum related legislation.
Sounds good. For Deborah, who said there's a clicking sound, I'm sorry that you're hearing something and that it's distracting. I'm on mute when I'm typing, so I don't think it's me. We'll try to minimize that if we can. I don't know where it might be coming from. The Refugee Protection Act is a bill that's been introduced multiple times but has never been passed. And someone else asked in the chat, I think, whether any of these bills have a chance of moving, and I think they do. In particular, a few of the ones that Grace mentioned, I think will get co-sponsors, will move slowly, but they will move. I'm hopeful that we'll get some support in the House and maybe also in the Senate. Will they pass all the way through? Will they get to bill signage? I'm not sure, but we're optimistic. It's worth it to try and put some effort behind them, because at the very least, we are making clear an agenda, and we're demonstrating solidarity and support for measures that allow both lawmakers as well as the administration to see where the advocacy community is landing. So it is important, even if we're not, oh gosh, let's put all of our time, energy, and money and resources behind a bill that might not go somewhere. We do demonstrate our support. We write letters, we show up at meetings and make sure folks know that we care about it, so that we're sending that message. The Refugee Protection Act is an example of that. Like I said, it's been introduced multiple times. It hasn't been successful, but we do nevertheless work on it. We encourage others to support it who are interested. Our team is working on it diligently as we speak. The Refugee Protection Act has a lot of pages. It's a very big bill. It is intended to really overhaul and fix a lot of problems that exist right now in our refugee and asylum system, both for those processing in and those who are here. Some of the changes, just a few that would help all asylum seekers and as well as immigrant survivors in particular. One thing is it would eliminate the one-year filing deadline. If any of you have ever handled an asylum case or know anybody who's applied for asylum, the one-year filing deadline is an impossible burden and is a ridiculous burden, frankly, for asylum seekers to have to meet. You're supposed to have figured out that you need to apply for asylum, know what it is, know that you qualify, found a lawyer, drafted your papers, secured your evidence, and sometimes our packets are that thick with information, and get that all submitted and ready to go within a year. Often people who come to this country are seeking asylum are not connected to folks of means and don't have a way to figure out not only what the law is, but what they might qualify for and how they can reach out and find an attorney that they can afford. And in my experience, having represented hundreds of asylum seekers in my time, there are very, very often you see a connection, a correlation between the most severely traumatized, the most devastatingly harmed, and the least likely to file within a year. And so the one-year filing deadline actually serves as a very good way to weed out the people who need protection the most. And so the one-year filing deadline really does need to go. There are legal arguments around it, but we waste a lot of time. I heard judges saying many times, I wish this thing was gone because I spend so much time just figuring out if we should hear the rest of this case. It's really not worth it. Prohibiting deportation while applications like U visas are pending. So even though the Refugee Protection Act is about refugees, people who have pending U visas may also qualify for asylum. So if they get deported while their U visas are pending, they never have a chance to even discover that they might qualify for something else. We need to protect them and keep them in this country. Establishing that the maximum number of refugees admitted will be no less than 95,000. So that is to say the cap has fluctuated significantly over the last 6-8 years. We've seen maximums at well over 95,000, and we've seen maximums as low as 20 and 30,000. And so our goal is to have there be a maximum that is never less than 95,000, which is the bare minimum the US should be accepting from around the world in terms of refugees processed in. That's not asylum, that's refugees processed in. And really it includes, and I tried to summarize here in one bullet point, but it includes a number of measures that would make it possible for asylum seekers to be paroled or to be released and to not have to live in jail while pursuing their asylum cases. It may also clarify, the current Refugee Protection Act is being discussed right now by advocates, but my hope is that it will go on to clarify that survivors of gender-based violence do qualify for asylum by clarifying and codifying what actually do we mean by a particular social group. Right now, individuals who are victims of gender-based violence, who are applying for asylum because they fear further harm on the ground of their gender, because gender isn't named anywhere, they are squeezing themselves in through a legal structure created through litigation around the idea that a particular social group can include people who belong because of their gender. That said, it does not go as far as naming gender as a ground for asylum. We at Tahirih believe that naming gender as a ground of asylum, as a ground for asylum, makes a lot of legal sense, and we certainly propose that. At the same time, clarifying particular social group for the purposes of the Refugee Protection Act would be a huge step in the right direction, and we also support that. So the Refugee Protection Act gets us pretty far in terms of being able to support immigrant survivors of violence as they realize they are victims of violence that could qualify for protection as asylees in the US, or as individuals who are seeking the help of our legal system to obtain asylum because of their gender and enter for that reason. There we go. Other asylum legislation that we're looking into, in addition to the Refugee Protection Act, include a work authorization act relating to asylum seekers, which has been introduced in the House. It reduces the waiting period for getting a work permit. EAD is an employment authorization document. So for getting a work permit to 80 days after filing, right now it's 180 days. So you have to, once you file, you have to wait for 6 months before you can get a work permit. The reason for that was really deterrence when it was written, that people shouldn't file asylum applications just to get their work permit, but filing an asylum application is such a nightmare. That's not really, it's not really necessary. People should be able to get their work permit 30 days after filing. And it should last for at least 2 years. So that's going into, that's in a bill that's currently introduced and is out there. Also reimagining the Asylum Processing Act of 2021, which was introduced in the House. It does a lot of really good and important things, modifying the process of claims, suggesting, for example, that we have humanitarian processing centers along the southern border. Why don't we just handle things without having to detain people, without having to put people through extensive border screenings, through court processing, through detention, living in jails and warehousing them for years sometimes. It's their human rights are being violated in the course of us trying to decide whether they qualify for humanitarian relief. Why not have a processing center where this could all be done in a humane way? Also would shift how juveniles are processed in particular, and make sure that individuals who come to the border and are being processed can have a screening interview, not only for asylum, but also for other kinds of protection, including special immigrant juvenile status, which we didn't spend a lot of time on, but is one of the other forms of immigration pathways that immigrant survivors of violence can access if they're juveniles and underage. So we wanted to close by offering you some resources. The Alliance for Immigrant Survivors, and Grace, jump in if you'd like, is an organization, an alliance, essentially. It's not really an organization. It's 4 organizations that Grace mentioned at the start: the Tahirih Justice Center, API GBV, Esperanza United, and Asista. And the 4 of us really hold at the center of our work supporting immigrant survivors of gender-based violence. And we do policy work as well as engage in different ways in supporting either advocates through technical assistance or clients themselves through direct representation and social services. And so our 4 organizations make up the co-chairs of the Alliance for Immigrant Survivors, but it is an organization that others can join. You can ask to receive our newsletter. So if you visit immigrantsurvivors.org, you can sign up for our newsletter right there on the website. People have been asking in the Q&A, how can I get involved? What can I do? I recommend joining our newsletter. We provide on a monthly, or if not more regular basis, opportunities for action. Here's a bill, here's a way to take action, here's a letter we're looking sign-ons, we're looking for signatures to. Sometimes it's individuals and sometimes it's organizations, but we welcome your engagement. Grace, do you want to say anything more?
Yeah, and so, on that very note right now, like I mentioned, the appropriations process is happening right now, and quite frankly, it's the most likely vehicle that will be passed, has to be passed this year. And to the extent that you are seeing cases, whether it be asylum related, whether it be U visa related, any of these bills, like we're looking for support in, the language in any of these bills to be attached to that process, or to, asking your members of Congress to support those provisions. And then, also as it relates to Alliance for Immigrant Survivors, we often share information about rulemaking that's happening, what's the latest regulation that is being worked on by the administration, how can we make sure that the administration pays attention to the needs of survivors of domestic and sexual violence and trafficking on there. We know that this administration is committed or has said it's committed to addressing domestic violence and sexual assault and human trafficking. And so to the extent that we can leverage that goodwill and that prioritization with the administration to make sure that immigrants are not left out in those conversations, we encourage your engagement and ask you all to be involved.
Thank you so much, Grace and Archie. This has been an incredible primer. I just want to flag for everyone that these experts have asked and have answered 17 questions in the Q&A box, and the information is there. The recording and the materials will be posted and made available. If folks want to get involved, as you said, you can get connected to the Alliance at the website that is listed here and receive the newsletter for ways to support and provide help. If a lawyer has an immigration case and they want to ask a question, kind of like the ones that came up, or they require technical assistance, where should they go?
I would start with, who we regularly refer to are folks to as ASISTA. They are the experts in the weeds. And, for those of you who are OVW funded, they are the TA provider, OVW funded TA provider for those of you doing the cases. And then they also have a program for private attorneys as well.
Fantastic. And their website is listed here as well. If there are any other questions, I don't see anything popping in. Thank you again to both of you. This is really, like I said, an incredible primer for everybody. And we will be posting the recording and the materials, and you can see the link to both the Alliance and ASISTA if you need support or assistance or to help out yourselves. Thank you everyone for joining the Commission on Immigration, the Civil Rights and Social Justice section, and the Commission on Domestic and Sexual Violence for today's webinar. Thank you.